So it is a pleasure for me to welcome you to the second day of our international workshop on the judiciary in territorially and culturally compound systems, organization and functions. I am particularly glad also because the proceedings today appear to be as interesting and stimulating as the ones yesterday, both due to the quality of our speakers this morning and to the interest, I would say, for the focus of our session, both in the morning and in the afternoon, which has to do with the principle of the reflective judiciary. And in fact, the question, the title of the session is a question which indicates by its formulation I would say, innovative character of speculation about this concept. The title is, How is or ought to be diversity reflected in the judiciary? One of the reasons of this is that we have, from the point of view of the very definition of a reflective judiciary, a variety of understandings due to the variety of the context in which the problem of a reflective judiciary is set. And I would say this is particularly interesting in European continental countries, or if you like, in the civil law traditions, as we do not have an experience, and in fact we don't even have any solid theoretical ground for having a method of political appointment of any judges, in particular of Supreme Court judges. As we all know, we have a career system of promotion. But it is true, though, that if you like, the most innovative courts that we have been experiencing, in particular since the end of the Second World War, is namely constitutional courts, namely an international court such as the European Court for Human Rights, a supranational court such as the Court of Justice of the European Union. All these innovative courts have introduced an innovative way of appointing of their judges, which is an appointment by the political institutions. And it is very rare that constitutional text give some criteria other than traditional, let's say, professional, other than traditional criteria such as professional skill and good moral character. In fact, even when it comes, for instance, to the European Court of Human Rights, it is only recommendations of the Parliamentary Assembly that have introduced criteria such as gender balance and knowledge of the official languages of the European Court of Human Rights. Of course, I don't want to go any further into a topic that will be taken care by Ida Torres this afternoon. But it was just to mention how we are experiencing new patterns of organization for new patterns of judicial intervention in public affairs, and therefore we are experiencing also the challenges of how to frame the court considering the variety of the plural fabric that somehow, whose interests somehow are going to be affected by the judicial decision making. And this is perhaps one of the reasons why we had to go yesterday through the examination of the practice and the legal framework which deals with the judicial autonomy of indigenous peoples as recognized by the Universal Declaration, as experienced by a number of countries, as enriched, I would say, by the presence of religious courts in countries such as the Malaysian Federation and Singapore. And today we are trying to, let's say, sort of speculate more, again, with a theoretical approach, but also with individual countries that have gone very far away in the direction of establishing a reflective judiciary. But here again, we have different patterns. In South Africa, let me quote the provision of the Constitution: the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. Must be considered means that nothing is really mandatory, if not consideration, which again indicates that we are not here in a field of rigid enforcement of criteria of representation, whether proportional, whether of any other sort. But the point is that the need is there. The need is there. And perhaps the need is there also as you consider, and we have seen that already yesterday, to what extent the solution of issues connected with pluralism is to some extent transfer from the political power to the judicial power. In other words, even in the areas of safeguarding pluralism and reflective pluralism, the judiciary is called into playing a rather large role. And perhaps also from this point of view, from the point of view of pluralism, the notion of juristocracy may have some sort of ground and foundation. So it was very interesting yesterday. It's going to be very interesting today. And I think that we are going to have a very good beginning with the first speaker, who is Fred Aman from the University of Indiana in Bloomington. He is too well known to make an extensive presentation. Let me just add, for the sake of the pride of this law school, to mention that he has been our distinguished Fulbright professor in the academic year 1998-1999, and since then he has come a few times back to Trento. So this, I suppose, is the third time that you come back after your Fulbright experience. We are going to have a break at 10:30. We may be a few moments late, but I'll try to keep the time as it was scheduled. So without further ado, I give the floor to Fred Emin, and thank you again for coming all the way from Bloomington to Trento.
Thank you so much, Roberto. It's an enormous pleasure and honor to be back and to see such old friends and colleagues and former students as well. And in typical fashion, to be back in Trento and to learn so much. I think this has been a very exciting conference, and I'm very appreciative for being allowed to be a part of it. My paper this morning is about diversity in federal and state courts in the United States. And my main argument is that we should promote a reflective judiciary for three reasons, at least. First, because in doing so, we gain critical awareness of barriers to judicial service. Second, because in doing so, we are also promoting access to resources, education, and opportunities in the legal profession. And third, because it is possible, although not automatic, that a reflective judiciary will broaden the range of experience and perspective on matters involved in the cases themselves. I'm going to focus on the first two of these points primarily, and then at the end give some attention very briefly to some individual judges that I think are interesting representatives of diversity. As you know, in the United States, members of the bar become judges only after a distinguished career, almost always in practice or in the academy. And there are no civil service exams to enter the judiciary. Under the United States Constitution, federal judges, Article III judges, reach the federal bench via presidential appointment and senatorial confirmation. States' systems are separate. State judges attain their positions in various ways. The formal routes include election, partisan or nonpartisan, gubernatorial appointment, legislative appointment, or nomination by commission, otherwise known as merit selection. The customary understanding of merit selection includes a nonpartisan or bipartisan commission that nominates a limited number of individuals to the executive, to the governor, when a judicial vacancy occurs for executive appointment, with continuing tenure on the bench dependent upon a subsequent retention election. In such elections, the judge is unopposed on the ballot, and voters are asked to decide whether or not to retain the judge. Some state judges, though, are elected directly by the public, like any other candidate for public office in partisan elections. Just last week, the Supreme Court decided a case involving the First Amendment and the ability of, in this instance, the state of Florida to restrict the ability of these state judges to actually personally ask for money in the campaigns. The court said that regulations stand. Diversity of the bench is directly related to how judges are appointed, of course, and especially the candidate pools from which they are appointed. Therefore, the consequences of a broadly conceived sense of diversity will not only foster judicial legitimacy, but also, I think, the most fundamental values inherent in our society: democracy, fairness, and inclusiveness, and, as I will especially argue below, access to education at all levels: primary, secondary, college, and law school. For the judiciary to be truly reflective, candidate pools must also be reflective. And for this to occur with regularity, access to education is necessary at all levels of society. Education is the primary pathway to the bar and ultimately the judiciary. A reflective judiciary is, therefore, like the canary in the mine. It's an indicator of access to education and to professional opportunity within the legal profession. When barriers exist to education, barriers exist to the judiciary as well. I could not, therefore, disagree more with Chief Justice Roberts of the U.S. Supreme Court than when he sought to bar the use of race to determine which public secondary schools certain children might attend. And he said this, he said, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." I disagree because the evidence shows that various creative policy initiatives are necessary if we are to attain a non-discriminatory society through educational opportunity. And I'll return to this point shortly. So in part one of this paper, I discuss various pathways to the federal and state judiciaries, gateways and impasses, bottlenecks, if you will. And I emphasize that access to the education and the fundamental role education plays as a gateway. As you shall see, progress has been made in the United States in the decades since the Civil Rights Act of 1964, but barriers persist. This is evident in the patterns of minority and female participation on federal and state benches. Appointment favors men over women and whites over minorities. So let's look at some of the patterns to identify some of these gateways and bottlenecks. Diversity matters at all judicial levels because, as published data will show, the judiciary is a bellwether for a democratic society, a yardstick to tell us how we're doing in terms of maintaining a democratic culture at all levels. A value on diversity throughout the judiciary, but especially at the top, exerts positive pressure all the way down. Moreover, systemic exclusion isn't healthy for society in general, or the legitimacy of the judiciary in particular. The importance of diversity to education and its direct connection to democracy and to leadership positions in the society was forcefully recognized by Justice Sandra Day O'Connor, writing the majority opinion in Grutter versus Bollinger in 2003. This was the case that reaffirmed the Bakke case that said affirmative action was constitutional. O'Connor writes as follows. She says, "We have repeatedly acknowledged the overriding importance of preparing students for work and citizenship, describing education as pivotal to sustaining our political and cultural heritage, with a fundamental role in maintaining the fabric of society. Moreover, universities, and in particular law schools, represent the training ground for a large number of our nation's leaders. Individuals with law degrees occupy roughly half the state governorships, more than half the seats in the United States Senate, and more than a third of the seats in the United States House of Representatives. The pattern is even more striking when it comes to highly selective law schools. A handful of these schools accounts for 25 of the 100 United States senators, 74 United States Courts of Appeal judges, and nearly 200 of the then more than 600 district court judges." I might add that on the Supreme Court now, all of the justices are graduates of either the Harvard or the Yale law schools. O'Connor concludes, "Access to legal education, and thus the legal profession, must be inclusive of talented and qualified individuals of every race and ethnicity, so that all members of our heterogeneous society may participate in the educational institutions that provide the training and education necessary to succeed in America. So race, ethnicity, gender, and income all structure access to education, and thus to law school, law practice, and the judiciary. An examination of the demographics of education and law practice tell a story of career mobility into the judiciary with education as the driver. The effects of education are stronger at each level up the judiciary and are strongest perhaps at the federal level. In 2013, the United States Census Bureau estimated that African Americans comprised 14.1% of the total American population. None of the top law schools regularly admits a student cohort that comes close to that percentage. Harvard recently did the best with 8.7% of its recent admissions offers going to African Americans. I don't know how many accepted. This is especially noteworthy since undergraduate admissions, not law school, but college, at some of the very top schools has gone up increasingly for minorities. Harvard, again, 12.1% at Harvard, 16.8% at Williams, which is a very elite liberal arts college, and that pattern, Princeton also continues in various undergraduate institutions. Overall, the distribution of whites and minorities in higher education generally has tended to improve, and since the beginning of the 21st century. In 2009 and 10, African Americans represented, now I'm talking about bachelor degrees, different than law degrees, but African Americans represented 12.5% of all bachelor degrees, Latinos 8.8%, Asian Americans 7.3%, American Indians and Alaska Natives 0.6%. Of course, talented undergraduates may choose careers outside of the law, and today I must say that that's happening with increasing frequency. But these differences, nevertheless, provide some rough benchmarks for us. High school education also varies by race and ethnicity. Children of poor families of any race and non-whites drop out of at higher rates than children of wealthier and white families. Dropout rates are improving, though, for all students, but they vary significantly by state and by class and race. The effects of poor high school education are, of course, compounded through a person's life. The study of law and the American legal system have played a major roles in efforts to promote racial equality in the United States. Yet the percentage of all lawyers, judges, law school students, and law school graduates who are African American is 9%, well below the percentage of the U.S. population. Of the 277 sitting federal courts of appeal judges, roughly 9% were African American, 5% Latino. Of the now 1,078 sitting district court judges, 11% are African American, and about 7% are Latino and 2% Asian American. Women are also significantly underrepresented on the federal bench, about 26% sitting on the Court of Appeals and 25% on the district court bench. The breakthroughs made by some elite schools at the undergraduate level have not transferred to law schools. In a recent survey of the top 15 law schools, Harvard, as I just mentioned, led the way with 8.7% of blacks extended offers in their incoming class. Others are well below that. Just picking a few examples, Cornell, for example, was 6.4%. University of Chicago, 5.5%. The law schools with the two lowest percentage of black students among the 15 highest ranked schools are the University of California at Berkeley, only 4.4%, and the University of Michigan, only 3.6%. The latter figures show the impact, I believe, of recent bans on affirmative action in both states in an apparent reaction to the Grutter affirmative action decision referenced above. Public law schools are prohibited by state law from considering race in admissions decisions. The same is true of Florida and Texas as well. And Gruder's viability as a precedent was watered down considerably by a differently constituted U.S. Supreme Court in 2013 in a case called Fischer versus the University of Texas. In an opinion that required only 13 pages, the court explained that a university's use of race must meet a test known as strict scrutiny. Under this test, a university's use of affirmative action still will be constitutional, but only if it is narrowly tailored, and that's a high bar, as the court explained it. The court in Fischer took pains to make clear what this means. Courts can no longer simply rubber stamp a university's determination that it needs to use affirmative action to have a diverse student body. Instead, courts themselves will need to confirm that the use of race is necessary. That is, that there is no other realistic alternative that does not use race that would also create a diverse student body. Justice Scalia wrote a concurrence, actually a one-paragraph concurrence in Fischer, in which he said that if Fischer and her lawyers had asked the court to do so, he would have voted to overrule the 2003 decision in Gruder and eliminate the use of affirmative action altogether. Justice Clarence Thomas, who is black and on the Supreme Court now, said in his autobiography, he blamed affirmative action for the problems he faced finding a job after he graduated from Yale in the 1970s. He discussed this at length in his 20-page concurring opinion, noting that, quotes, the arguments advanced by the university in defense of discrimination are the same as those advanced by segregationists. The court has a version of Fischer on its way back up and may or may not grant cert. I think they probably will in the near future. The fact is that public universities have now developed significant enrollment gaps in states where affirmative action is banned in college admissions: California, Florida, Michigan, and Texas, as I said. This finding helps account in part for the bottleneck mentioned earlier in the transition from college to law school. And it shows the relevance of public policy, though, I think, and legal supports for maintaining the conditions that support a reflective judiciary. Turning from law schools to the bar, we note that only 3% of the lawyers at large law firms are African Americans, and only 1.9% of the partners are African American. This is a significant bottleneck since judges often come from the large firms. At least that's an obvious place to look. There are other sources as well, but that's certainly a big one. On the federal level, however, some progress has been made with respect to male minorities. Of the U.S. Circuit Court judges, 51.2% are white men, 25% are white women, 16.7% are non-white men, and 6.8% are non-white women. So altogether, 48.8% of active circuit court judges are women or minorities. As we shall see, though, there are significant variations by state and by region. For example, the 11th Circuit Court of Appeals, Federal Court of Appeals, which covers Florida, Alabama, and Georgia, and has the largest population of African Americans, 25% of the population of those states, has 8 active judges and 8 senior judges. They're retired, but they sit with frequency. Of those 16 jurists, only 1 is black, a black male, Judge Charles Wilson, who was appointed by President Clinton in 1999. Wilson, in turn, replaced Judge Joseph Hatchett, who was the first black judge to serve on the 11th Circuit since its creation in 1981. It was split from the 5th Circuit in 81. There has never been a black female judge on the 11th Circuit, and there have been 6 vacancies on the court since President Obama took office in January of 2009, but he did not nominate a single black man or woman to fill them. He has nominated 1 Latino man and 4 white women, and the Senate confirmed 2 of these nominees, Alberto Jordan and Beverly Martin, both of whom were Clinton District Court appointees. Here we are perhaps most likely witnessing political bottlenecks as Republican-dominated Senate delegations of these states in particular vigorously resisted many, if not most, of Obama's nominations. Looking to the future, the U.S. demographic is becoming more diverse in ways that should favor increasing diversity in all of our institutions at all levels, if education and the professions are reflective of the population at large. But that's a big if. The demographic shifts in the United States are maybe just as likely to make more visible the obstacles to equal access and participation. The future demographics changes place an even greater premium on access to quality education at the primary and secondary levels of education, as well as affordability, and all these things are changing. Affordability of college and law school itself. So who can qualify as candidates for college even as our demographics change and become more diverse? Well, high school dropouts cannot. And some commentators have written the United States is facing a dropout crisis with an estimated 1.1 million members of the high school class of 2012 not earning diplomas. And poverty and dropouts are inextricably connected. In 2009, poor, namely the bottom 20% of all family incomes, poor students were 5 times more likely to drop out of high school than high income, 20% of all families in the top, all of students from those families. Child poverty is rampant in the U.S., with more than 20% of school-age children living in poor families. Poverty rates for Black and Latino families are 3 times the rates of white families. The Supreme Court has not been very supportive when it comes to advancing affirmative action with regard to high school students. In Parents Involved in Community Schools versus Seattle School District, written by Chief Justice Roberts, and the quote that I made in the initial part comes from that case. The Supreme Court held that the use of race is unconstitutional in that instance. The school districts had not carried their heavy burden of showing that the interest they seek to achieve justifies the extreme means they have chosen, discriminating among individual students based on race, by relying upon racial classifications in making school assignments. In an eloquent dissent, Justice Breyer, took issue with this ruling and put it in the context of democracy. He said this: there is a democratic element here, an interest in producing an educational environment, thus that reflects the pluralistic society in which our children will live is at stake. In light of this court's conclusion in Grutter, he continued, the compelling nature of these interests in the context of primary and secondary public education follows a fortiori. Primary and secondary schools are where the education of this nation's children begin, and where each of us begins to absorb those values we carry with us to the end of our days. So in this context, it's important to note not only is there a dropout crisis for the poor in high school, but those that do try to go to college are finding it increasingly difficult. Many of what once were reliable gateways to higher education for poor and middle-class students are changing significantly, as many public universities essentially have become privatized, and as state funding recedes and costs and tuitions escalate significantly. Nationally, women are entering higher education and postgraduate education at higher rates than men. This is true for all racial and ethnic groups. Women's greater participation in education is especially marked in poorer and more rural communities. This suggests that efforts to sustain a reflective judiciary in terms of race and ethnicity should automatically increase the percentage of women. Recent Bar Association data show that women are increasing as a proportion of the licensed bar, only 8% in 1980, but increasing each decade to 30%, well, in 2005. I don't have the current numbers, but probably slightly higher. But the proportion of minorities has not changed in the same period. Given the importance of a successful legal career as a pathway to the bench, the members of minorities in major firms and minority women in particular are of importance. But here appears to be another bottleneck on the way to the judiciary. Minority women make up less than 2% of the partners in the nation's major law firms. Actually, 1.8% 1.84% of the partners. This group is thus particularly underrepresented in the partnership ranks, even more so than minority men, who account for 4% of the partners. The representation of minority women is only slightly higher and at the very largest firms. At the state level, the Brennan Center for Justice has indicated that diversity on state courts is far worse than the federal level. Quotes, today white males are overrepresented on state appellate benches by a margin of nearly 2 to 1. The report points to implicit bias in the formation of the candidate pools, as well as to failure for effective outreach and things of that matter. In addition, I would add that the pools that are presented are fragile. They're not as deep. You may have some women in minority, but if for various reasons, and there are many personal reasons why people would say, well, you know, I have children in college, I can't afford the pay cut or whatever, they're not easily replaced. There's a very deep pool of white males, and I think some of that has something to do with this. So we've been reviewing rationales for a reflective judiciary based on the ladder of educational and professional opportunity. But those are not the only rationales for a reflective judiciary. Judges are the human face of the law, and the international as well as domestic observers look to the court's composition as a measure of how well the law represents and is accessible to a diverse population. In a recent memo to the Georgia governor advocating for diverse nominees, the Georgia Supreme Court, a retiring Georgia Supreme Court judge said this. He said, unquestionably, judges are influenced in their notion of justice by their unique life experiences. It would be a travesty to the population served if their justice is reflected only in terms of the white male experience. Experience matters both in informing the court's opinions and in ensuring that the population feels part of the process and not an outsider looking in, as Justice Sotomayor, when she used the famous phrase, a wise Latina woman, was indicating. Well, I was going to turn to 3 vignettes of 3 judges, and in the interest of time, if you like, perhaps I could show a video of one of those judges. This judge, I had 3 judges that I wanted to illustrate the unusual nature of their selection process and how many barriers they broke. This one is Constance Baker Motley, the 9th of 12 children, born in New Haven, wonderful high school student, never thought she could ever go to college, though she wanted to, and gave a talk at a community center one night. Yeah, we're coming to this. Gave a talk at a community center one night. A person heard her and came up to her afterwards and said, what are you doing with your life? Are you in school? And she said, no, I can't go to school. There was no way I could ever go to school. My parents are poor, we don't have the money. And this man, this was at Yale, was in New Haven, was a benefactor of Yale, his name was Clarence Blakesley. He said, I'll pay for you. I'll pay for your education. This is in the 40s. And so she goes down south to Fisk University. Her parents were mortified because they had never gone across the Mason-Dixon line, and they were very worried for her. She spent 2 years there and then transferred to NYU. And then from NYU went to Columbia, once again paid for by Clarence Blakesley, and went on to this incredibly brilliant career. This clip, if I might, is filled with, I think, hope and this was her reflecting. I did a whole bunch of interviews with her and other judges a long time ago about their cases and whatnot. And here she is reflecting on her very first case. But the context of it and what it meant, not just to her, but to the people who saw her participating in this way, I think was extraordinary. So if you allow me, I'll press the wrong button if you don't do it. As well.
Well, the first time I walked into a Southern court was in Mississippi, in Jackson, Mississippi, in 1949. that is, a case in which I actually participated. I sat in on a case in Maryland, tried by Charles Houston, which opened the nursing school at the University of Maryland to blacks. And Thurgood Marshall had sent me down to sit in with Houston so that I could learn how to try cases. And I have never forgotten that experience, because he was one of the best trial lawyers, I guess, in the country at that time. He had every question he was going to ask written out in a notebook, and never departed from his prepared questions and his exhibits all prepared and that kind of thing. And it was really the only education I got in actually trying cases. We didn't get that in Columbia Law School. They didn't have clinical courses in those days, and they certainly didn't have civil rights courses. But anyway, Judge Carter was the chief counsel in a case in Mississippi in 1949 for the equalization of black teachers' salaries. Now, this is long before Brown, and this was an area also in which the Legal Defense Fund had done an extensive amount of work, again within the separate but equal context. That is, they brought suits to equalize black teachers' salaries because black teachers were uniformly paid less than white teachers to teach the same subject, so to speak, in the South. And Mississippi was one of the places where nobody wanted to go, even then, for fear, again, of economic reprisals. But the teachers in Mississippi, the Black Teachers Association, raised the money because a black lawyer locally had to be paid to file the suit. None of us were Mississippi lawyers. And even in the federal court, we could be admitted, but a local lawyer had to sign the complaint, and somebody who had been admitted. And in those days, we found a black lawyer who lived in Meridian, Mississippi, who signed the complaint, and the Teachers Association paid him $1,500 to do that. That was a lot of money in 1949 in Mississippi. But that's all he did in the case. And we went down, Judge Carter and I, to get ready for the trial, to prepare our witnesses and that kind of thing. And we had employed a statistician from Atlanta, a black man, to do, the statistical analysis of the qualifications of the teachers and their salaries and their assignments and so forth. And we had to go over that. We were there for about 10 days before the actual trial. The trial started on a Monday afternoon. I'll never forget it. We walked into the courtroom, and it was packed and jammed. Every seat was taken. And the thing about it was that those who were lining the walls were all black, and the whites were seated. And Judge Carter told the blacks after the session that day that there was no segregation in the federal court, so they could sit anywhere. In the state court, blacks had to sit in the balcony or in the back or something like that. So the next morning at 9 o'clock, when the case resumed, we got to court, and the blacks had gotten there early, and all the seats were taken by blacks. So the question was whether whites were going to stand while black people sat in a public place, something which had not happened in Mississippi in this century anyway. It may have happened during Reconstruction when blacks controlled the state, but not in 1949. So what the judge did, Judge Mize, he apparently directed the bailiff to open the huge doors to the courtroom and leave those doors open so that the whites could parade by and see the Negro lawyers from New York, as we were called. They couldn't say Negro, they would say Negro lawyers. And the local paper that day had written up the fact that one of these Negro lawyers was a woman from New York. and so that brought out, I guess, an even bigger crowd, because they had not seen in Jackson, Mississippi, any lawyer in court in this century, and they certainly hadn't seen any black women lawyers. In fact, they hadn't seen any white women lawyers, for that matter. So it was quite an attraction. So the case proceeded each day as white people paraded by to see these two black lawyers from New York. And James Burns was the name of the man from Meridian who was the lawyer who signed the complaint. Now, James Burns, I said, even at that time, was 1 year older than God, and he had grown up in Mississippi. I don't know when he passed the Mississippi bar. He really did not practice law. He didn't go to court. I think what he did largely was probably real estate transactions and deeds. And he did that in his grocery store as a part of that activity. And I remember the first day we went to court, he wasn't going to examine any witnesses or anything. He sat with his back to us at the counsel table, making notes, and he made notes the whole time with his head down, just making notes. I think the man was fearful of what might happen to us, you see. He had never experienced anything like this in his lifetime. That is, black people challenging the system in the same way that the whites would challenge the system, by taking a case to the federal court, which, like in many communities, was something most people weren't even aware of, you know. And they certainly never had any business with the federal court. And all they knew it was the United States government, and that was something different. So he sat there the whole time writing notes. And at lunchtime, at dinner time, he'd disappear. You know, normally lawyers on the same side of a case would go out to lunch and dinner together. We were all from out of town, but he always disappeared. And the second day of the trial, Bob Carter said to him, go outside and see if our witnesses are out there. And he got up from his seat and bent over with his head almost to the ground, walked out, you know, in deference to the court, so to speak. In other words, he didn't want the judge to think that he was doing something for which he should be reprimanded, walking out of the court. So he wanted to demonstrate that he was being humble, as black people were expected to be. And he went outside, came back and said, yes, and the witnesses were outside. And every time he had to go out, he went out in that fashion. I couldn't believe it. But anyway, the last day of the trial, when it was all over, he said to me, because Judge Carter wasn't speaking to him by that time, he said to me, you know, I'd stay and have dinner with you all, but I have to go home and bring in the wood. My wife is sick, and I have to bring in the wood, you know, for the stove. And so I said, oh, yeah, I understand. But he went out the very last day standing erect, like a human being, walked out of the court when he had to go out to see whether the witnesses were there. Now, the reason for that was that the judge, Mize, acted like one would expect a federal judge to act. He treated us courteously. He addressed me as Mrs. Motley, which the lawyers didn't do. And he ruled with us on many motions and objections. Now, his final decision was against us. But as he wrote in the opinion, the only reason that he was against us was because the Fifth Circuit had just ruled in the case from Atlanta on the same subject that you had to exhaust administrative remedies before you brought such a case in the federal court. This was a 1983 case. Now, 20 years later, the Supreme Court ruled you didn't have to exhaust administrative remedies, but here we were in 1949 being thrown out. And he found, of course, that blacks were uniformly paid less and that we had otherwise prevailed. Now, during the trial, for example, when the superintendent was on the stand, he was speaking in his low Southern style manner, and Judge Carter got up and said, Your Honor, would you please ask the witness to speak up so I can hear him? And the judge said, yes, speak up so the lawyer can hear you. Now, to everybody in the courtroom, particularly the blacks, they had never seen that before. That is, a white man telling another white man to speak up so a black man could hear him. And that night, Judge Carter said he went to the barber shop, and everybody in the barber shop was reenacting that scene. They thought that was the greatest thing that had ever happened. But again, you see, Mr. Burns, who walked out like an animal, gradually straightened up when he realized that there was a forum in Mississippi where black people could take their cause and be heard. Even if the judge ruled against you, he had not known that in Mississippi, a black man could go to court and be a lawyer like any other white man and be respected. So that was my first experience in a Southern court.
Well, thank you all for coming. Judge Motley was the first black woman to be appointed to the federal bench in 1966 by President Lyndon Johnson. Well, in event, I'll end it there.
Thank you very much, Fred, also for this gift of this movie that was extremely interesting. And now we have about up to 15 minutes for some discussion, and I'm prepared to see any hand being raised in order to have a question. Yes, please. Simone? Yes, I'm sorry. It will get.
Good morning. I'm Simone. I'm working here in the faculty. I really agree with the view of interpreting reflective judiciary as a means for strengthening social equality, and you started mentioning the method of appointment, and I guess that is, apart from the access to education as a condition to the access, is a decisive element, the method of appointment. And I was wondering whether competitive examination, such as in Italy, public competitive examination, could be more functional to guarantee than by the executive or parliamentary appointment, more functional to guarantee representation of social pluralism. When and whether reflective judiciary is intended as a means for removing obstacles to a more comprehensive access to the judiciary. So in this term, what we lose in terms of democratic legitimation of the judiciary, we gain in terms of social representativeness of the judiciary. And I think that the history of the appointment in Italy, you finish with a case of women in Italy. I think that since women had the right to access, which is not so, we took quite a long time from the entry into the force of the Constitution. Actually, women reached more or less the 50% of the judiciary. There's still being a sort of glass ceiling for accessing the directive roles within the judiciary, but maybe this method of appointment could be more functional and more effective to increase the quality in access and opening the judiciary to social pluralisms.
Well, thank you.
Mia, I think we collect a couple of.
Okay, sure.
We have 3 at the moment.
Right.
Mia?
Thank you. Thank you very much for your presentation. I was very surprised by your referral to the Gratter versus Bollinger decision, because as I understood it correctly, you were making a comparison between diversity in classes in education and diversity in the judiciary, while as I'm trying to understand diversity in the judiciary, in my understanding, diversity in the judiciary should promote something else than just diversity as a symbol of democracy, fairness, and justice, meaning, of course, it is the symbol of a professional opportunity for women, for minorities, for everybody. But could it be, and this is my question, and I'm sorry if I'm oversimplifying it, could it be that if a bench is diverse, this could have an effect on the delivery of judgments? I mean, if a black woman is appointed, or a black woman, or I don't know, judge of some specific religion or something else, is he expected to deliver a different judgment, reflecting the desires and interests of the people he's representing? Because this makes the difference. I mean, I totally agree that judiciary should be diverse in order that women could access federal judiciary or the Supreme Court, such as blacks, such as, I don't know, everybody. But are they expected to deliver different judgments? And just for example, I never understood if Sonia Sotomayor was appointed because she was representing the career opportunities of Latinos women, or because Latinos women could be more represented when she was deciding matters that affected their situation and condition. Sorry for oversimplifying it. Thank you.
Good question.
Thank you very much. One more question, Jens. No, here, Jens. And then we have...
Maybe she was first, but...
I didn't see your hand, I'm sorry.
No, it's all right. You go, I'll ask.
Okay, no, very...
No, because then I would like to have a round of answers, and then we take another round of questions.
It's also linked to what Mia said on the stage before, and I appreciate very much what you explained us and all the data you gave us on the educational side, because this is often an excuse also for not admitting too much diversity, because people are simply not prepared, and merit-based criteria are objective, and so you have a reason of excluding people. And so I think this is extremely important. And I just wanted to ask whether there, in the dialectics between politics and law, politics and courts, and you have actually already given part of the answer, quoting the affirmative action bans in state constitution and also the reaction of the court in some case. Is there a kind of clear line to see, so that is there a constant jurisprudence in one way or the other?
On affirmative action? Yeah. Well, let me start. I think the method of selection is a very interesting question, and my research thus far reveals, and others have said this, so that in our system, not the Italian system just yet, but in our system, it seems to make no difference. There's very little, maybe if you probe deeply in a certain area, a certain region, a certain state, it could be that merit selection is a little bit better than election or not. But by and large, most of it comes out pretty much a wash in terms of who gets to the judiciary. As for a competitive examination, I don't think it's been raised in any serious way in the U.S. context, in part because though some judges will start at the lower trial level, the expectation is that you would take somebody who has tried cases. If they're going to be a trial lawyer, what matters is that they have tried cases, they're well known to the bar for their expertise and their ability and their lawyer-like qualities. And that is, I think, paramount in terms of who gets into the pool. Also, so many of these appointments are at a higher level at the judiciary, and the thought there, that's why partners in law firms matter and whatnot, because people who are trying complicated financial cases, for example, there would be more interested that there is somebody sitting there who has some kind of experience, perhaps, in that arena. So, I think your suggestion is an interesting one. I don't see it fitting in the U.S. situation, certainly not at the appellate levels at all. And the other methods have not made much difference. I mean, that was surprising to me. I thought something would emerge, or that elections would certainly be the worst, but there's no, it's a bit of a wash, total wash, actually. As to Grutter, you raise an extraordinarily difficult question. I mean, clearly the idea of a judge is that they are fair and impartial, and that's the essence. So some of it is that from a democratic society, you should be able to find fair and impartial judges from all walks of life. Now, in the quote that I gave from that retiring judge in Georgia, basically he's saying, of course judges rely on their own experience. Of course it matters where they're coming from and what is inside of them. My old judge, this would have been one of the vignettes, and I'm overspending my time, but one of my vignettes would have involved Judge Tuttle, who I clerked for. Judge Tuttle was born in Hawaii, or he's from Hawaii, grew up in a multiracial, multicultural society, and he finds himself chief judge of the major Southern court deciding civil rights cases. He often said that he knew his wife was Southern. That's how he ended up down south. He married a Southerner. And he said he knew that all of this was harder for his wife. He said, but growing up in Hawaii, he had such a multicultural, multiracial experience that it just, the issues were not hard for him. Once he was stopped by a policeman. He was driving home a friend of his who happened to be black. And this was such a rare occurrence that a white man would be driving, this was, in the 30s or, early 40s, a white man would be driving a black man in Georgia in the car, that he was stopped. And he said, no, he said, nothing's wrong. I'm simply taking my friend home. So clearly, there's a lot of experience that's brought, and diversity is likely to play into that, but I don't know one can predict how outcomes then would be, how, Justice Thomas.
If I may, she said expect, not predict. So I agree with you, expect. You can't predict.
You can't predict.
But she said you can expect.
I think the experience is that there's a great deal of difference. So Justice Thomas is black and votes very, very conservatively on most issues. Similarly, George Bush appointed a black woman to the D.C. Court of Appeals, Janice Brown, extremely conservative. And you can predict how she's going to vote on things, but not because she's black or because she's a woman, but she came to the bench quite openly with a very strong philosophy of a certain kind. So, but I do think all members of society in a democratic society should be eligible and should be represented. Now, Sotomayor, Sotomayor was my third vignette. I could spend all morning, I won't. But Sotomayor was my third vignette. And that one was so interesting because she used the phrase wise Latina woman. She felt that she was bringing something to the discussion, not necessarily outcome-oriented, but she had a different experience. She had a different perspective. And, of course, she almost lost the nomination for saying that. And too much to go into, but the idea of race and how it played out in the hearings is extremely interesting, because it then became, for her opposition, a way of delegitimizing her and delegitimizing the use of race. And here you have a Latino woman who's been a judge, and it became a way of saying she is a surrogate of the Obama administration. You know, he's black. She, you know, I mean, that was the implicit subtext of a lot of the difficulties she had in walking back a statement that she had made to a student group many years earlier, and had often repeated in her speeches to young students, in trying to encourage Latino women to go forward. So I don't think, I think fundamentally the expectation is that you are going to have a diverse court and that it will be a fair person, but we should be able to, but I don't know, it's a complicated one. As to affirmative action, Jens, if is that okay? Okay. I think the line is getting clearer and clearer, and with the current majority on the court, if they take the Fischer case up, they took Fischer, they remanded it back to the lower courts to determine whether race was the only factor, and it could have been diversity could have been achieved otherwise. I don't know how that court's come out yet. Maybe they've decided or are about to decide, but I'm quite certain that case will come back up again. And Scalia has already said, ask us to overturn, So there's a clear line. I mean, for the Supreme Court, you're barely going to get a clear line, but it doesn't look good. At this point, I would say it doesn't look good.
Okay, thank you. Debbie, the microphone, please.
Fred, thanks for your presentation. I really enjoyed it. And I agree with you about the need to improve educational outcomes if you're going to sustain change in diversity in the judiciary. My question is about a program I'm aware of operating in New York called something like Legal Outreach, where they take selected students, talented students, I think from high school, and then they expose them to a range of networks and mentoring and really kind of give those kids from disadvantaged backgrounds the kind of experience they need to be able to then get into the law schools and colleges they need to be able to get into. But I'm wondering how common those programs are, or whether that's an isolated kind of program.
I think
that two more questions.
Oh, I'm sorry. Yeah.
Three.
So good question.
Marco
answer, right?
and Cheryl and myself. Oh, I'm sorry, and Laura as well.
Yes, thank you for the presentation. Mine is a question.
Did you try before? I hadn't seen you. Okay. I'm sorry, Mark.
No worries. Mine is a question, but it's also a general comment that perhaps we may take into account in considering the topic we are dealing with today. I think it was Harold Lasky that in describing the UK judiciary said that English judges were the unconscious servant of a single class in a community. And that was a criticism against the very non-diverse selection of judges in the United Kingdom. So what we are proposing now is to go precisely in the opposite direction, to have a more representative, with all the qualifications we have to do to this term, but a more diverse judiciary, which is seen as doing justice and not just doing justice. And there was, for all the criticism we may express against the older idea of a homogeneous branch of judiciary, there was an advantage to that. By being homogeneous, it was rather predictable. Whereas when we move towards a more diverse judiciary, this increases also the uncertainty and unpredictability of adjudication. So this is, I don't know if there are specific researches connecting the level of diversity achieved to some extent by the United States judiciary, at least at the federal level, and the degree of divisiveness within courts. I would like to ask Professor Aman whether there is such type of research, or if he has an educated guess if this is actually true. So if there is, if the high divisiveness existing now is also a reflection of the reflective judiciary.
To Professor Saunders, first line. Okay. And then the three of us.
Fred, I agree with you that it's very hard to put your finger on exactly what difference it makes to the substantive outcomes if you have, say, a woman on a court. I mean, there's all sorts of other advantages, but the substantive question that was also raised by your question is difficult. But listening to the exchanges over the same-sex marriage case in the US Supreme Court the other day, or at least reading them online, and everybody was falling into their usual stances for and against same-sex marriage. And then Ruth Bader Ginsburg came up with a point, and I thought, God, I wonder, I certainly hadn't thought of it, and I thought, I wonder if someone who wasn't a woman would have come up with it. Now, maybe they would have, but let me tell you what the point was. So she was responding to the argument that marriage has been between a man and a woman from time immemorial, and how can we change it? And she said, yes, but the relationship has been one of subordination from time immemorial, and it's only the man owns the woman and blah, blah, blah. And it's only relatively recently that it's become a relationship of equals. Of course, you couldn't have had same-sex marriage before because both of them would have been men. But now that it's a marriage of equals, you know, things have changed, and why can't you have same-sex marriage? And I thought, maybe that's an example of the difference, not the representation in the sense of your question, but just the difference of a slightly different way of thinking about an issue, or maybe just being more interested in an issue might produce. Anyway, it's just an example.
No, great comment. Thank you very much for all these questions. Very helpful and stimulating. On the outreach, there's more and more of this. I don't have the specifics at my fingertips like this, but for example, the American Bar Association recently has called for mentoring, greater outreach, and approaches, I think, perhaps somewhat like the New York. So there's a kind of a top-down aspect where they're talking about this. This Brennan report that I mentioned, which came out not too long ago, made a number of recommendations that I think are being picked up that have to do with outreach and mentoring and things of that nature. But in the context of merit selection committees, they recommended that the committees themselves be more diverse and that they affirmatively take steps to interest candidates to think about becoming a judge. So I think that this is something that is going to increase, and I think that's a hopeful sign. This is a very interesting connection, I mean, that you're making between diversity and divisiveness. I guess I don't know of any research on that. I think my gut reaction is that it's not connected. In most instances, I can think of examples where there may have been some, but let me. One of the other vignettes I had was of my own judge who I think there's divisiveness, but it's philosophical, and it's case-oriented, and it has to do with who wins and who loses. And I don't know if that connects necessarily to a diverse, increased diversity. My own judge, Judge Tuttle, appointed in the South, was a Republican and a white male. In fact, on my wall in my office, I have a picture of the Fifth Circuit Court of Appeals that I clerked for. It consists of 19 white males, and it was around circa 1970. And no one thought strange of it, you know. It was like, well, but Tuttle was a Republican appointed in the South. The South was Democratic, white, and the Democratic Party at that time completely racist. They would not allow a black person in the party, which is why Tuttle became a Republican. And he was, in effect, you know, literally joining the party of Lincoln, and affirmatively so. So when it came time to appoint someone, Eisenhower was president, and Eisenhower ended up appointing some of the most courageous and creative federal judges in the South. Did far better than Kennedy did on the Democratic side, because Kennedy had a lot of political debts to pay. And so I don't know, you know, in terms of divisiveness or whatever, I mean, on the one hand, you wouldn't have expected, I guess, if you expand it to that kind of diversity, and someone was coming on the court, in the Southern Court, who already had a very specifically public position of being an integrationist. So in that sense, the judge brought other views to the court that certainly upset some of the members. Interestingly enough, his cohort was Judge Brown from Texas. Brown was from Nebraska originally and was appointed. Then he had Wisdom from Louisiana, who was a true Louisianan, but they were all Republicans. And that's what's so strange, you know. Now it would seem strange. Then they simply were fish out of water. They couldn't participate politically in the groups there. It doesn't really go to your question exactly, but I think there's divisiveness on the courts, and I think it doesn't connect so much with diversity as it does with other issues of the day having to do with sort of the economics of everything and the role of government and libertarian approaches or not. And I think those kinds of things are coming from lots of different people and not necessarily diverse, but it's a very interesting question. I got to think more about it. And I take your point about the Judge Ginsburg is a great one, and you know, in some ways, I think that's what Sotomayor was also suggesting, that there are people who bring a body of experience to the court. Tuttle did the same thing, although, you know, as I say, it didn't look that way, but he did. Coming from Hawaii, having a very multicultural background, and then being on that court at that time. But I do think that certain people who have had, you know, these political careers where they have had to stake out and courageously pursue certain issues. I wouldn't doubt that if Constance Bakers Motley were on the Supreme Court and race cases came before her, she simply knows her way around that world extremely well. So I do think that it does play out, but it's a tricky one given the role of the judge and the stereotyping that can then go on, you know, in reverse, in a sense, you know.
I apologize for the late coffee break, but it is, as you all, I hope you all agree, it is too interesting just to skip the three more questions that we have. So Laura and then Alexandra. Oh okay.
Mine's less of a question and more just maybe to sort of add some extra remarks to Fred's answer. There has been research that's done looking at the destabilizing effect of when you encourage diversity in courts. So there was a piece done by two Canadian academics, Marie-Claire Belleau and Rebecca Johnson, and so they analysed the dissenting patterns of women judges on the Canadian Supreme Court. And the answer to that question is it depends on the judge. So they saw with the early judges like Bertha Wilson and Claire Laure-Daubé that they were dissenting more than their male colleagues. But you have to put those women in context, and you have to also put them in temporal context. These were appointments during the 80s. Their views were could not be said to be sort of mainstream, and they were feminists. They were real feminist judges. Quantitative outcomes-based research in this area is really unreliable. So there have been a lot of US studies looking at whether women will vote differently to men, and the result is inconclusive. There has been some positive findings in migration appeal tribunal decisions, but the statistical significance of them are not enough to draw firm conclusions. That also draws me to Cheryl's point with Ruth Bader Ginsburg. The question we should always ask is, was that because she was a woman, or is it because she's a feminist? And those two things are not necessarily the same. So was it that her feminist conscience that made her sort of question the institution of marriage, or was it her gender? And then I finally just wanted to say something in response to competitive examinations, and this is where we really bring out the need to be careful as comparativists, looking at the civil law jurisdictions and common law jurisdictions. So competitive examination has, in civil law countries, seen a greater increase of women in the judiciary, but you have to realise that that's because it's career judiciary, and competitive examinations are usually taken at an entry point into the profession. So they're able to have an element of examination which is not socially subjective, so written exams that are marked blindly without knowing the gender of the candidate. There's been some research done in France. Professor Anne Bourgel has looked at the French system, where we see a lot of overrepresentation of women in the career judiciary. And what she says is, as soon as we enter into a socially subjective aspect into that testing, we see women performing worse than men. So as soon as they have to give oral presentations, and as soon as they're being examined, they fall behind their male counterparts. One of the reasons suggesting why that is so is because those who are assessing the candidates are self-replicating, and those who are assessing are not a diverse bunch in themselves. You also pointed to the interesting thing that even in career judiciaries, where we're seeing an overall overrepresentation of women, it's not trickling up to the higher levels. You also need to realise that common law jurisdictions and civil law jurisdictions, there's a level of prestige attached to judges in common law jurisdictions that isn't in civil law jurisdictions. I mean, that's made out by the fact that UK judges earn, I think, 6 times the same amount as the highest level judges in France to the highest level judges in the UK. So once again, we get these issues of power, and that women, even in competitive examinations, can get in at certain points, but whether or not the power relations are preventing them from going up.
Now, I know the topic that I'm going to raise is of no interest to Fred, but still, I would like to ask you, because it seems to me that the very issue of diversity in the judiciary does offer more speculation than the one which is related to the sort of bottom-up direction. That means how to introduce social progress, social justice, social equality in allowing all segments of the population to reach any position in all sectors. The point is that it is important to add the judiciary to business, to academia, to performing arts, so that a chance is given to everybody. But I join Mia in trying to figure out if this has effects which go farther than the bottom-up direction, but also from the top down. That means the judicial output, the judicial effect, the judicial consequences of diversity in the judiciary. Now, from what you say, it seems that this is not relevant because still a judge must be fair and impartial. And I totally agree with you. The point is that comparative analysis indicates that some other characters seem to be required, or at least suggested, other than just impartiality and neutrality. In other words, the practice of the United States with establishing the seats at the Supreme Court, how is it that since, I would say, the 30s, you have a Jewish seat, and I go in chronological order, if I'm correct, a Jewish seat, a black seat, a woman seat, a Roman Catholic seat, a Latino seat? Is it just, it is only the press that is calling the seats the way I just indicated, or is there the understanding that those who make the appointment have some expectations of a more fair, more impartial, more unpredictable in terms of innovative judicial decision making? In other words, what Marco was saying was that it was predictable, but it was not innovative, and of course society is mobile, there are social changes, and so you have also to allow social changes to pass through, and the instrument to letting them pass through is by having diversity in the judiciary. So again, I don't think that this practice in the US is just a number of cases. It is not casual, but it is on purpose that such appointments are made. So this is why I think that perhaps more speculative elaborations may be needed in order to understand whether it is a practice, more than a practice, and what is the rationale for this practice. If you consider, as I indicated earlier, that some constitutions have written in the Constitution that it must be so. So in the US, it is so. But why? In South Africa, it must be so. That's the reason for raising the issue again.
Yeah, no, well, it's a political process, and for a political process to be fair, everyone has to be able to participate in that political process, number one. And number two, when there is a movement afoot to say, we want more women in our judiciary, we think we're going to get more fairness. I mean, I'm not saying a specific case can be decided a certain way, but we think we're going to get more fairness in the sense that a deeper perspective, a broader perspective is going to be brought to bear on the kinds of issues that we think are important to society these days. And this changes with time a little bit. So, for example, you were talking about the seats on the court. Right now, it's 5 Roman Catholics and 4 Jews. And for the first time in a long time, there's no Protestant. And that's extraordinary. And the other thing that's dropped out pretty much is region. A little bit, I suppose, it might come up, but nobody thinks in terms of, gee, there's a southern seat. Justice Black was the southern seat, you know, and actually when Judge Tuttle was talked about for the Supreme Court, it was because Justice Black was ill, and they thought, well, we have to put a southerner on to place a southerner. And this changes. So what political point is going to be made, with the next appointment, I don't know. But I don't think that's bad as long as there's a pool of candidates out there, and we're not just always going to the well in the same fashion. But I think that these are political appointments, and there's nothing wrong with that. I mean, politics it's not venal. It doesn't have to be. It simply has to be, wait a minute, we're a society where we have a different perspective on the world. We think things are changing in certain ways. We would like to see somebody up there who has some kinds of experiences that can reflect on those political interests. And philosophical, but many times specific groups. When Brandeis went on the court, I mean, he was bitterly opposed because he represented the poor and unions and things of that nature. So, but the political moment seemed right to bring someone on that way. I don't know if that's an answer to your question, but so practice as opposed to customary law, I mean, there's a practice there that is political.
Okay.
And it needs to be truly and deeply and fairly political, in my view.
All right, let me just add, since some figures have been given earlier this morning, that from the Law School of Trento we have 1/5 of the members of the Constitutional Court of Italy and 1/9 of the members of the International Criminal Court. Professor Politi has been the judge at the International Criminal Court. So we are taking part to the banquet, let's put it this way. A much smaller banquet will take place in the same room, this coffee break, and I think we can give ourselves 15 minutes. I'm sorry, not more than that, because then we have 2 more papers and more discussion. Thank you, and let's go to the coffee break.